Hey y'all, Rob here with ATX Legal, and today I'm going to talk a little bit about bonding and some changes that just went into place in Texas regarding how people bond out and how people can get something called PR bonds or Personal Recognizance bonds. And just so we're on the same page, bonding is before you've been convicted of a crime, but after you've been arrested. It's the way that you get out of jail. And of course, that's a big part of my job, is when a family or a client calls me and they're in custody and they say, can you get me out of jail? Is there a way for me to get out? Before we're even taking it to court and fighting his case in court, the very first thing we're doing is seeing if we can get him out of custody, if he's not out of custody already. Now, the new bill that just went into place beginning December 1st, and some of it will take effect in January, but the majority of it took place December 1st. It's called House Bill SB6, and it made some sweeping changes to bonding and specifically to when people are going to be eligible for PR bonds. Now, a PR bond or personal recognizance bond it's basically free. There is like a $20 or a $40 fee, but you don't have to go pay a bondsman thousands of dollars in surety to bond out. It's a free bond from the court, and the court will offer that at its discretion, or it used to be able to do that. The new bill takes away a lot of that discretion from judges to give a PR bond to people who would have qualified before. And specifically, we're talking about people charged with violent offenses, people who are already out on bail or on probation for a violent offense, or anyone who's been charged with a failure to appear. And the way it's written, even if there was never a conviction on that failure to appear, that would still prevent you from giving a PR bond. And pay attention to the language here. It's actually taking away that discretion from the judges. So even if a judge looks at a case and says, this is a really minor case, I think a PR bond is warranted, there's going to be no problem in the community, he's going to come back to court, that judge, if one of these things apply, would still not have the authority to give a PR bond. Now, and I'll touch on this more later, but there are some ways that judges could get around that. For example, they could, even though they can't give a PR bond, they could theoretically give a $1 bond. I haven't seen that happen yet. This only took place in December. I have had it affect a couple of my cases so far. But as far as judges who want to circumvent this issue by offering very low dollar bonds, $100, $1 bonds, could theoretically be allowed by this bill, and it'll be interesting to see if that does play out in the future. And SB6 also expands the definition of what a violent crime is. It's hundreds of different charges. I'm not going to list them, but just know that the universe of charges that are considered violent crimes has expanded with the new law. There's also a provision that a judge can deny bond if a person charged with POCS, that's possession of a controlled substance, refuses to submit to a drug test. That hasn't really been a part of bonds in the past. It's not something that will necessarily take effect. It'll be interesting to see if the judges actually use that provision, because that does leave it up to the judges to allow that. But because it's written there, you could have a situation where a judge says, you're going to have to take a drug test, and if you don't pass it, you're not getting a bond. So that's one more way that this law just tweaks the bonding just a little bit. Okay, in addition to restricting PR bonds for certain clients, it also restricts what courts are able to hear bonds. So if there is a pending charge, that the new charge has to be heard in the court where the original charge is. So how does that affect things? Well, in Travis County and in a lot of especially urban counties, there is a magistrate on judge 24 hours a day, and that's for if someone gets arrested, we can go to that magistrate to get a bond, and he can get out relatively quickly. Well, if he has to wait to go back to the court where his case is being heard, well, that court might not be back in session until Monday, or if there's a holiday, it might be out for an extended period of time. Well, under this law, he would have to wait until that court is in session and bring that PR bond request or bond request to the court where the pending charge is. So that could definitely cause delay in certain situations where in the past we'd be able to go quickly and get a bond. Now there's already some confusion with this. I got an email from the courts and they just put in a standing order in Travis County where the magistrate judges are basically deputized for the district courts and the county courts, so that in certain situations it looks like we're still going to be able to go to the magistrate, but there's still confusion as to whether that is going to hold up and whether that's going to be allowed. And I do want to make this a two-part video. I want to give you this quick overview right now as the bill is taking effect, and then I do want to revisit it in a few months when we see how the courts interpret the new laws and ways that judges and attorneys come to terms with the new requirements under the law. There is one interesting thing that we don't know how it's going to play out because this law has not been in effect for 90 days. There is a requirement that if the prosecutor is not ready for trial within 90 days, then the person must be released. So in a case where a judge doesn't have discretion to release someone on personal bond, but let's say the district attorney is on board and they say that this person should be released, well, they could be complicit and allow for the 90-day time period to elapse without indicting, and the person would be required under the law to be released. Now, by the letter of the law, these are two contradicting laws in place. So one saying he must be released, another law saying he may not be released with a PR bond. So how will that be resolved? No one really knows yet, but it'll be interesting to see what happens once that situation does arise. Now let's take a more high-level overview, getting into more of the ideology of it. Texas and really nationwide, we've been moving more towards a cashless bail system. And what that does, instead of making whether you get released based on how much money you have, it's going to be based on other factors. Are you a danger to the community? Are you a flight risk? And then based on those factors, we decide to release people before they've been convicted of anything, so that they can live their lives without having to remain in custody. This is a huge step in the wrong direction. So bonds are now going to be based more on whether you can afford it, not based on the factors, whether you're a danger to the community, whether you're going to return to court. Those are now secondary. What's primary is, can you and your family come up with $1,000, $2,000, $10,000 to get you released, so that you can be free while you await your trial. People forget, we're talking about people who have not been convicted of anything. They are awaiting trial. We don't want to punish people wrongly, and that's what will happen here. There will be people arrested falsely who remain in custody because they cannot afford bond. And now we've taken away that discretion from the judges to go ahead and, let's say there's a weak case. If it's one of the violent charges enumerated in SB6, doesn't matter how weak the case is, the judge does not have that discretion to release them on a PR bond. It's really shameful. I think that we're going to have some really terrible situations where people are in custody for a long time on false charges because of this bill. Okay, so bottom line, charges like DWIs and sort of non-violent crimes, really there's very few of them, but there's a subset of charges that are not going to be affected by this. But anybody charged with a violent crime, or if they have a violent conviction in their past, or if they've had a failure to appear in their past, bonds are going to take longer to get. They're going to be more expensive, and in certain cases, people are not going to be able to bond out at all, and they're just going to have to wait in custody while their case goes through the courts. It's not a good system. It's definitely a step in the wrong direction. My hope is that there's some pushback both on constitutional grounds and just on human empathy grounds once people see how this bill takes effect and how it works in practice. But anyway, I do plan on revisiting this issue in a couple months, so look for that video if you enjoyed this one. Go visit us at atx.legal if you or a loved one is facing charges. Look forward to taking your call, and thank you very much for watching.